So today we're going to be focusing specifically about mediation in the landlord and tenant context where both parties are what's called pro se, which means they are not represented by an attorney. So the mediation project started around 10 years ago, specifically to use mediation as a tool to reduce the number of evictions in St. Louis City. And since then, we have expanded into St. Louis County. And so this particular docket is pretty much every Friday morning due to the special circumstances where under those have been, or that docket has been paused and everything has been continued out. But it's going to be usually every Friday morning starting at 9:30 a.m. and going until about 11:30 or noon. So in Missouri, there are three main types of eviction processes. And so these are, and each one has slightly different elements. And so the first one is what we call rent and possession. And this is the most basic of eviction cases. We're going to go through and define each of these and a little bit of their elements in just a second. So this is just a quick overview of the evictions. The second one is called unlawful detainer. So when someone unlawfully holds possession after their possession should have ended of a unit. And then the last one is going to be emergency evictions and ejectment actions. Those are very rare and they're usually pretty hard for a landlord to prove. Usually it's going to require some type of violence or pretty intensive kind of drug use or trafficking or production out of the unit. So in the typical court process, so we're in what's called the Associate Circuit Court. And so the Associate Circuit judges often are in rotation. And so they'll do a rotation of the housing court for approximately 1 year. And some judges will stay on longer. So for example, Judge Nicole Colbert-Boschway has been doing it for a few years, but Judge Lynn Perkins just started in January. So every year it's a little bit new and fresh, but generally it's a very informal procedure with relatively loose evidentiary rules. So it's very rare, particularly within this docket, to hear objections or to really follow those really intense rules of evidence that you might see, especially as lawyers become involved. So whenever a judgment is entered against a party, it becomes final after 10 days. So that means that usually the tenant has 10 days before the landlord can what's called execute the judgment, where they take it to the sheriff and the sheriff physically evicts the person. Whenever we're talking about leases, there's two main types. So the first one is what's called a fixed term lease. These are usually written, and it's, if anyone is a renter here, hopefully you have a fixed term lease, which means that the tenant agrees to rent the premises until a certain date, and then usually there's a full contract. The other main type, and we see a lot of this, is an unwritten month-to-month lease, which means that the rent is set, but there isn't a written lease in place. Generally, these leases are a lot more flexible. They don't have fixed terms, and usually the notice requirement for these is about 1 month. And lastly, in Missouri, you have a right to a jury trial in eviction cases. We don't see that happening a lot, especially because many of the folks that we're seeing in our court or in this particular docket don't have attorneys, so they don't know that they have a right to a jury trial, or they might not know how to make that happen. So again, the first main case is, or this is the main one that we see, is a rent and possession case. This means that any amount of rent is owed, but unpaid, right? So, and this could be as little as $1. Different judges have different thresholds about how much rent actually has to be owed in order to enter a judgment. But under the statute, it means any amount of rent is owed, but yet unpaid. So the landlord may file for other types of money owed, and that depends on the action and the judge. So sometimes you might hear them ask for utilities, additional repairs, late fees are often put in there, those types of things. For rent and possession, there is no separate notice required. So the assumption is that the person knows that they should pay rent, and by failing to pay rent, then they are breaching the contract. And so the landlord may file this type of case. And then for these types of cases, there's two main types of service. So you can post service on the property, And if that's the case, we are very rarely working with those parties. Um, just because many times if it's posted, the tenant won't show up. But if someone posts on the property and the tenant does not show up, the most that the landlord can get is possession. So if it's posted, you can't get monetary damages. But if there's personal service, which means it's handed to the person or a family member or another resident of the unit, then the landlord can ask for what's called money damages. And so that's going to be rent and those types of things. Right? So it's possible for, even if service is posted, that someone will show up. And usually that's something that the supervisors just kind of keep track of. It's very rarely going to come up as necessary for your actual mediations. Occasionally you might hear someone say, well, they never gave it to me personally. They just put it on the door. By showing up in the court, they've what we called availed themselves of the court. So it's as if they received the summons in their hands. Same thing at that point.
I have a question.
Sure.
How can somebody, like, I guess, prove that they handed the post to the person in person? Like, if they just lied and said, oh, it was just posted, but how do you, like, go about proving the difference, I guess?
Yeah, so generally that's not something that we'll have to worry about, because even if there's an issue with service, if the tenant is there, then they have kind of waived their notice requirement unless there's a whole special kind of action in place, which we never really see. Typically, though, you have to have what's called a process server. So either the sheriff or some, a company who goes and then files what's called an affidavit of service. So you
Okay.
might hear that come up sometimes.
Okay. Thank you.
Yep.
And if I can just add one little point on it too, the other thing is that the rules for service in the state of Missouri are very, very low. So for example, the posting doesn't even technically have to be on the door of the apartment. It could be on the front of a larger multifamily building. And so it just is very rare to see service, even if you have an attorney, to actually see service kind of fought over in Missouri courts.
Yeah. Thank you. So we'll continue on. So the other type of case that we're seeing, so some other kind of key pieces, whenever the landlord files the complaint, it creates what's called the prima facie case, which basically means that if the defendant doesn't show up, the landlord already wins. And that's because they have to file an affidavit. Again, that's not going to be super relevant in the mediations, other than you might hear a tenant say something like, well, whenever I received the papers, the landlord said that I owed X amount of money, and that's absurd. I don't owe that much. That doesn't really affect kind of our mediation, other than you might hear a tenant pissed off about it. And so if any amount of rent is owed, the court must grant the landlord possession. So the Missouri statute is very landlord friendly, particularly in terms of possession. So keep in mind that if a mediation fails, if the tenant admits that some amount of money is owed, generally speaking, the landlord will get possession. Now, we as mediators don't usually say, if you don't mediate, then you're going to be kicked out of the unit. Usually we'll say, what do you think the judge will do? What do you think would happen if the judge gives, a judgment to the landlord? Those types of things. But this is just for your knowledge, but this is a generalization. And then lastly, there's a right to what's called a trial de novo, which is a new trial, but the tenant may only stay execution. So first, this has to be filed within 10 days, and the tenant may only stay execution by paying what's called a bond, which means you pay it into the court, equal to the judgment plus court costs, which quite frankly, we're usually working with folks who are very poor. And so it's very rare that someone can afford the full amount of money plus court costs within the 10-day period. And that doesn't guarantee that they'll get that money back, by the way. Just means that they have a new trial. So tenants have what's called a right to cure. So if they pay all of the rent owed plus the court costs before the trial date, the action is dismissed, okay? Which means the action goes away. If they pay the rent after the court costs, or after the trial date, rent plus court costs after the trial date, the landlord must accept the payment and file what's called a satisfaction of the judgment, which means that they can't keep that judgment out there as open and pending. And if a landlord refuses to accept payment, we'll talk about that in a second, but it's called a waiver. And lastly, the landlord-tenant relationship abides. So it means that they are allowed to continue in the unit. And this varies a little bit about whether it's a fixed term lease or a month-to-month lease. A month-to-month lease usually already has notice of kind of ending of that relationship. So that's where that really comes into play. So if there's a fixed term lease and a tenant cures, then they're allowed to stay in the unit unless there's another breach of the contract. Okay. Whereas a month-to-month lease, that might not be the case. Okay. So here are some of the main affirmative defenses. Usually these have to be, or technically they're supposed to be filed prior to appearing in court, but you'll hear all of these come up in mediation. So first is breach of contract, which means usually the landlord was supposed to do this or rent this unit and they didn't. So I don't need to pay rent. That usually doesn't, we'll get to that in a second. So the second one is what's called waiver, which means I tried to pay rent, but the landlord refused to accept it or refused to accept the full amount of rent. I tried to pay the full amount of rent. So the third one is called breach for violation of implied warranty of habitability. So in every contract for housing, there is an implied warranty or guarantee that the unit is habitable. That does not mean that it has to be nice. It just means that it has to have the bare necessities. So basic utilities, heat in the winter. Missouri does not require AC in the summer, but other states do. It means no exposed live kind of electric wires, no major holes, no substantial pests, those types of things. And so again, that's supposed to really be filed prior to appearing of the court. And there's a whole kind of process about implied warranty of habitability. You don't really need to know it. But even if a tenant raises one of these defenses, the judge rarely refuses to grant the landlord possession. The only time that we really see that refusal to grant possession is a tenant tried to pay the full amount of money and the landlord outright refused it. That's the only time. And it's not a month-to-month lease, but it's a fixed term lease. So those are the main ways that we're seeing. So generally that's going to, usually the landlord is going to get possession. And so when you're in a mediation, it's important to kind of keep that in mind as you're thinking about what are the consequences to not mediating. And I did receive a question, does habitability imply an occupancy permit? Not necessarily. So habitability is a slightly different bar. Occupancy permits are set by local statute. Habitability is set by what we call common law, which means that the judges and the courts make that. So sometimes they might overlap, but not necessarily. Usually if there's not an occupancy permit, then there's some other legal things that come into play that are really not, they're not really within the gambit of what we address, okay? So the next type of case is what we call an unlawful detainer. So this means that the contract, whether it's written or non-written, has ended and the tenant is still there, okay? So there's a specific required notice and so there's a specific required notice, and that's sometimes set by the contract. If it's a month-to-month lease, and all of these are kind of on the slide, so I'm kind of jumping around on the same slide. If it's a month-to-month lease, the standard is going to be 1 month, okay? If your contract ends on a certain day, then no notice is necessary if that day is the final day. So let's say you're leasing an apartment until June 1st, June 2nd rolls around and you're still in the unit, you might be in this kind of unlawful detainer category, okay? And usually the notice has to be written So, but that does include text, right? So if a landlord, just kind of says something, then that's not necessarily going to apply for one of these unwritten or month-to-month leases. But if a landlord texts a tenant that you have to be out within 30 days, that might qualify for that proper written notice. So for an unlawful detainer, there's some unique pieces. So first of all, a landlord can recover double rent. So we will tell you whether it's an unlawful detainer or rent in possession case. Usually we might have one or two unlawful detainer cases in a given docket. So of 40 cases, we might have one or two at a given point in time. And it really just kind of affects what are the alternatives to reaching an agreement. And so again, if you're wanting money, you have to have personal service for the money, and you're required to first attempt it. So they're unlikely to give an unlawful detainer. If it's just posting, it's going to be slightly different what they'll allow. Reduced affirmative defenses, partly because you're staying there after you're supposed to, and the process for appeal is pretty much identical. You have within 10 days you have to pay an amount equal to the judgment plus the court costs. Keep in mind that that's double rent, so that can be even more expensive. Any questions about unlawful detainer?
Yes, you saying you can recover double rent from people?
Yeah, so let's say that we had a lease for me to rent to you until March 1st, and now we're on, what is it, the 21st? I could collect a prorated share of 21 days times 2. Yeah. And the process is that someone is living in a unit without permission of the landlord. And so they allow recovery of double rent. So here's the overall timeline that we're working with. Most of you will be working in the city to start. So your first appearance is usually about 3 weeks after filing. So if the landlord files the case, they're given a court date, usually about 3 weeks out. And service is usually effected within that first week, especially if a landlord is familiar or used to the eviction process. So in the city, the day of that trial, the day of first appearance is usually a trial in the city, unless both parties agree to continue or there's some special circumstance. So let's say, a party says, I'm really ill, and they, excuse themselves, and they are really sick, then they might be able to get a continuance. Or if someone's in the hospital, usually that's what's required. In the county, however, either party has a right to continue to the next available date. And the county dockets are a little bit less regular. They're Tuesday afternoons from 1 to 4 p.m., but not every Tuesday. They're approximately every other week. And again, those are on pause due to special circumstance. So those dates are a little bit more tricky. So keep that in mind. If one of the parties in the mediation says, I'm not going to reach an agreement until I have a lawyer. I need 2 weeks to get a lawyer, right? They technically have the right to do that. So if they make that type of request and they're not interested in reaching an agreement today, just let a supervisor know, and we will kind of let the judge know what's going on. And usually the judge will ask us to help with drafting the continuance paperwork. And so lastly, the landlord may file with the sheriff to execute the eviction after 10 days. And so you're looking at about a little over 4 weeks for a complete eviction to occur under normal circumstances. And keep in mind that 10-day before eviction is really important as you're thinking about what are the alternatives to mediation and an agreement, right? So we'll chat a little bit more about what those are. So the sheriff then schedules the physical eviction, which usually takes about 2 or 3 days, maybe. They set what's called a schedule, and you can always call to figure out what the current schedule is. Generally, they'll post on the property, they'll warn the tenant. They try to make sure that tenants have the opportunity to kind of get their stuff out before they're kind of going in and making that happen. Keep in mind that the landlord might be financially responsible for a moving company to remove the tenant's personal property. So this depends a little bit on jurisdiction, but the sheriff themselves are not going to remove the stuff. Someone else has to do that. The sheriff will generally just get the tenant out. In the city, the landlord may be financially responsible for storing valuable property. So bear that in mind. The landlord has those upfront costs. And then Sam, you can correct me if I'm wrong, but I believe if the tenant wants those things back, they have to pay for the storage costs. Is that correct?
It's a bit of a gray area, probably unsurprisingly, but yes, basically ultimately any kind of the removal of the property is ultimately can be billed to the tenant. I think it's questionable whether the landlord can withhold the property until the tenant pays, but that is how some people interpret it.
Got it. Thank you, Sam. So whenever someone is a Section 8 voucher holder, a tenant, they are usually not financially responsible for the housing authority portion. So if a tenant pays 20% of rent and they pay their 20% of rent, generally the landlord cannot evict them if the housing authority does not pay their portion. So the housing authority may refuse to pay, especially if the property fails one of their inspections. So they have a higher inspection threshold than a general occupancy permit usually. So if the property fails that inspection, the housing authority may withhold rent. So if that's the case, the landlord cannot evict the tenant for the housing authority's portion. Okay. They have a whole separate process that we won't get into. So if you hear that a tenant is on Section 8, it's important to kind of bear that in mind. What is their responsibility? And then another thing to consider if you're working with a tenant who is on a Section 8 voucher, any judgment against a tenant may lead to their removal from the voucher program. So a judgment of eviction disqualifies someone for Section 8 housing. Okay. And again, we're giving a lot of this information just so that you know what are the alternatives to reaching an agreement by mediation. Okay. Usually, we, as much as possible, try to prevent and reduce the number of judgments of eviction. And mediation is a great way to make that happen. So some other negative effects of eviction that we often see or talk about. So we're really talking about folks with relatively low income who are unable to pay rent. Sometimes it's folks who are just barely making ends meet and something bad happens. Other times it's folks who are in an emergency. Sometimes it's folks who aren't paying for any number of reasons. And whenever there is an eviction, there's lots of negative effects broadly. So on an individual's education, on their health outcomes, but also local crime in the area and likelihood of incarceration in the future. There's increased costs to the community to address homelessness, mental health, and other related challenges. The landlords end up paying more because the eviction process is timely, they're not getting their money, and they have to turn over units. Eviction records last for a very long time, and you have to kind of go through a special process to get that sealed. To get it sealed in the future can be very challenging. So if they want it sealed now is kind of the time to do it. And then also know that many landlords will not consider, so they'll refuse tenants with eviction judgments, even if they were never physically evicted. So even just the judgment alone, even if it's a default, can often be enough for a landlord not to consider a tenant. And so usually we find that those landlords who will accept tenants with eviction judgments often have lower quality of units, right? So we find that kind of recreates the cycle of poverty where they're charging extra for a lower quality unit because they're willing to rent to someone that they call high risk. Right?
And
So
we'll just to jump in quickly too. Like one
yep.
example of it that we see quite a bit is a higher security deposit, right? So Missouri law allows you up to 2 months of a security deposit, and if you're a person with an eviction, you're almost certainly going to be asked to put in a higher security deposit because in effect you're a higher risk for that landlord.
Yeah, thank you. So our overall mediation process, some of you have already seen it, many of you have not. Most of you will probably start your observations in the city. So we only mediate if both parties are present, which seems obvious, but it's actually more complicated than it looks. So we'll talk a little bit more about what that means where both parties are present in a little bit. So generally a supervisor will assign the cases after the judge calls the docket. So when the judge calls the docket, they're calling the names of all the parties. And then if there's a matched pair, then the supervisors will track it on our list. And then we assign each of those cases to a mediator. So once a mediator is assigned a case, we'll give you the paperwork and the names of the parties and the case number, the information that you need. You'll then stand up in front of the group of people. You'll say the names of the parties, and then you'll ask them to follow you into the hallway. And that's true of both the city and the county. Once you're in the hallway, you'll find a place to sit, which sometimes is more complicated than it sounds. In the city, it can be pretty loud. The county is a little cushier. They've got carpet and some nice little cubicles. But the city, there's some tables that are set up in chairs, and you'll see it the first time you come in. So in the beginning, you'll do your introductory statement and talk about the agreement to mediate, which we'll cover in a little bit. But this is where you introduce yourself, you say who you are, and you cover kind of the groundwork of what is mediation. So if you've worked with a party in a mediation in the past, so if say you're working with a repeat player or someone else that you've mediated with before, you have to let the parties know. Generally, they don't care, but you have to at least let them know. And we'll cover that, the ethics of that towards the end. So you'll say that, so it's important to know that the parties must sign the agreement to mediate prior to the mediation. This is to protect you and to protect the project, and we'll cover all of the ways it protects you in a little bit. If the parties do reach an agreement, so remember, your job really is facilitation. If the parties reach an agreement, you can help record the agreement. So you're going to know the paperwork. For those of you who are lawyers, you're very familiar with drafting contracts. You might be familiar with drafting motions. And so you'll be familiar with that. For folks who are new, we're going to do another session later on in the future about legal drafting. So if you're unsure how to draft a legally binding agreement, we'll talk about that in a future session. So the mediator, once you've recorded the agreement and folks have signed it, you'll approach the supervisor for review of documents. This is especially true for newer mediators. You might find that an experienced mediator just takes it directly to the judge. Don't do that until we give you the okay. We don't, just because we've had judges get upset, especially if an agreement is not drafted the way that they want it. So the supervisors can be really helpful, especially in the beginning, about getting that language right. And then you'll approach the judge to review the documents. The judge will usually sign only the continuance. And we'll talk a little bit about what that is in a little bit. When folks are new to the training, or if you kind of forget that little piece about the process, the judges are not afraid to tell you exactly what they think about your agreement. And they assume that you are a full-blown mediator with our project and have been doing it for years. So sometimes they will assume that your mistake is incompetence. So just keep that in mind. So part of this is to protect you, part of it's to protect the parties, and part of it is just to kind of mitigate the challenges of navigating the court system. So once the judge has signed the agreement, your job is to you are responsible for the copies. So in the city, you will stamp the, you will approach the clerk to stamp it, or the clerk has an automatic stamper that just says that the paper has been filed, and we'll walk you through it in person. So you just kind of need to know the overall process. In person, it'll make a lot more sense. In the city, so you'll stamp it and then you'll make the copies yourselves. In the county, the clerk does everything. So you just wait and then the clerk will give you the copies once those are done. If the parties do not reach an agreement, just let the supervisor know. In the county, you should ask whether the parties want to try the case today. If they already continued the case once, then they're not, they have to, the parties have to agree to continue the case again unless the other party wants a continuance. Okay. But in the city, it's assumed that it's a trial unless the parties consent to a continuance or there's some emergency circumstance. Okay, so you'll just let a supervisor know and we'll handle it from there, and we'll move you on to the next case. So here are all of our paperwork. Here is all of our paperwork. So there's 5 main pieces of paper that you'll be working with, and you're going to have a copy of each of these. I'll repost them into the chat in just a little bit. And so we'll talk about what each of these does and their role. So the first is the agreement to mediate. I'm sure for many of you, the text is super small. Again, don't worry about reading the whole thing now. You'll have an opportunity after. But this really does outline an explanation of the program, who we are, what we do, what's the role of the mediator. So we are not fact finders. We make no guarantees of outcomes. We're not judges. We're really just facilitators. And we're really just trying to reach an agreement between the parties. In here is also a provision about confidentiality. And basically what it says is, if someone says something in a mediation, the other party cannot subpoena us or force us to testify on their behalf in court. Okay. So this just protects you from having to be called as a witness whenever person A says something in the mediation and then the agreement doesn't work. Person B tries to call you in to say that person A said something in the mediation. This agreement prevents that from happening. So that's part of why signing it is super important, because otherwise there's a chance that you might be forced to testify, and we don't want that to happen. And then lastly, it recognizes that our services are free of charge. So they're not paying us. So we don't owe any duties typically afforded to clients because of that.
And Wolf, can I add one more thing too?
Yeah.
The other important thing that actually comes off fairly often is sometimes people think that we are working for the court in some like respect or capacity. And it's good to clarify that we are absolutely volunteer and not being paid by the court or even associated with the court too. We're just a completely independent body.
Right. Thank you. So the next is what we call the continuance. So for folks who are lawyers or familiar with legal settings, you might find that this continuance is different from most continuance documents. So this is what we call a conditional continuance, which means that the date is continued to, or the court date, or the trial, sorry, the case is continued to another date. So that just means that the parties showed up today and we are setting the case for another day. That's all that continued means, okay? So this is the only document that's signed by the judge and filed with the court. So this is the only one stamped. The clerk gets a copy of everything except for the agreement to mediate, but this is the only one that's stamped with the court stamp, generally speaking. So you'll set a continuance date. Usually this is the date after which the agreement is complete and the court has pro se housing docket. So in the city, that's going to be a Friday. Double check on the calendar to make sure that court is in session that day, especially since there's 2 divisions in the city. And if one division might have court, but the other one won't. And so if you set a continuance date for a date when that court is not in session, then that can cause some challenges for the parties. If the agreement is for a very long time, then you can choose the last available continuance date, and the parties can come in and ask or renegotiate a new continuance date. Okay. Oftentimes we find that if we set that far out of a date, the agreement is either breached or completed already by that time, or the parties just aren't willing to continue the agreement. Usually, you know, a substantial portion of it has been completed. And so sometimes people just won't show up, but that's what we'll often do. So for example, right now, we have county court dates until June. So if an agreement is until July or August, right now the only available option is to set that last continuance court date in a, you know, once if the parties are okay with it, and then the parties can come back on that date to just re-up the continuance to a new date. Okay. And usually we'll give you a list of possible dates in the county, but in the city, the calendars are very large and posted. So just don't pick a date that has an X on it and you'll be okay. And so you'll see that the continuance has this language here, case dismissed so long as. Those lines are where you're going to write the main body of the agreement. So we've repeated here the case dismissed so long as. So again, you'll see that kind of right here. I can put an arrow here. Okay. And so the language that we use has there's a few different types. So the first is what we call possession only, right? So case dismissed so long as the defendant, and this is the part that you would draft, the defendant vacates the property on or before December 31st of 2018. And this is a slightly older example, but the language is pretty much identical. So the defendant vacates the property on or before a certain type. If the defendant does that, then the case gets dismissed. Okay. There was a question about the agreements. Someone asks, do we read the agreement out loud verbatim as CRC does in co-mediations? The answer is no. We summarize it and then give the parties the opportunity to read it. So whenever you're doing that, don't force them to sign it super fast. So I'm usually very intentional and I say, here's what the agreement generally says. You have a right to read it. I encourage you to read it. Whenever you feel comfortable with the agreement, you can sign at the bottom. Okay. Thank you for that question. So we've got possession only, so vacating the property. Sometimes you might see the word quit there instead of vacates, means the same thing. The second one is a payment plan only. So the case dismissed so long as the defendant pays the plaintiff X amount of money by a certain date and Y, or X or Y amount of money by another date. Right. So under the first condition, the defendant must leave the property by a certain date in order to satisfy this agreement. Under the second form, the payment plan only, the defendant only needs to pay by a certain date in order to complete the agreement. Does not require a move out. So we often find that if a landlord wants a tenant to stay, we'll use a payment plan option. You might also see, especially with payment plans, the defendant pays this amount of money in addition to regular rent. Okay, so you can either calculate what is total rent when combined with the payment plan, or you can just say the amount of money paid in addition to regular rent. I also try to keep in mind, like, what could a person reasonably pay? So if the landlord says, oh, well, I need $1,000 every month, ask the tenant whether or not they could reasonably make that happen given their income. So the third one is a combination of possession and payment plan. So we've got this vacating the property on or before a certain date. And so in the law, the way that we combine sentences or clauses is very important. So we have this and here. So defendant vacates and pays money. So that means that the defendant has to do both of those things in order to satisfy the agreement. And then lastly, for this slide, always ask about court costs. So oftentimes we'll put in sometimes a special payment, and we'll just label it court costs, just for clarity so that folks remember what they're agreeing to. So some other language that we use a lot, especially when a main issue is landlord repairs, is we will have a payment plan dependent on landlord repairs. So that means the defendant pays this amount of money. In exchange, the plaintiff, so the landlord, must make a certain amount of repairs. And we'll talk a little bit more about how that plays out with the next piece of paper. Okay. If the defendant does not pay, the landlord must show that those repairs were made in order to get the judgment, which we'll talk about. The next one is payment plan or possession. So remember we talked about ands. Well, this one uses the or clause, or uses or instead. So defendant may pay a certain amount of money or vacate the premises on or before a certain date. So you either pay or you leave. You have to pick under this scenario. And it's important to use this on or before language. You might think that it's implied, but as any lawyer will tell you, do not take such things on faith or faith alone. The last one that we use is possession or springing money judgment, which means defendant leaves by a certain date. If not, the plaintiff may file the consent judgment for possession and a certain amount of money. You don't necessarily need to include the language, if the defendant does not vacate, the plaintiff may file the consent judgment for possession and X amount of money. That language does not need to be included because of the way the consent judgment is used. But if a landlord is very insistent that if the person doesn't leave, then they want their money, then you can put this in and it won't hurt. Okay, it's redundant, but it doesn't hurt the agreement. And again, if you're confused about the language of drafting, to become a mediator with our project, we require you to observe 2 mediations. Then you will lead the introduction in 2 mediations, and then you'll observe after that. Then a co-mediation for 2 sessions, and then you will be shadowed for 2 more sessions. So after 8 mediations, you're totally good to go on your own. That might sound a little daunting. Usually it takes about 3 times of showing up to make that happen, just because we have so much volume of cases. So 2, 2, 2, 2. So the next piece of paper that we use is the consent judgment. And this is what's filed if the parties violate the terms of the continuance. So these are signed by the parties the day of the mediation, but not the judge. If a party violates the agreement, so that if they violate the continuance, the other party, usually the landlord, must bring the consent judgment to the judge and ask for the judge to sign it. The process is a little different in the city and the county. In the county, you can come in on any landlord-tenant docket day. So you have to call basically the landlord has to call the clerk and ask for the next docket day. In the city, they don't require that. You just bring it into the clerk's office, and then they'll direct you to the judge, who will then sign it. And then you'll notice on the agreement itself, partway down, it says, with costs of this proceeding assessed to, and again, you'll receive a full copy of this, costs of this proceeding assessed to, and that's where you just circle who's going to pay. Or sometimes the judge will waive costs. If you don't ask who is going to pay, that can be a challenge in the future. So just make sure that you're asking. And if the parties are like, whatever, the plaintiff's like, I already paid it, then it's assessed to the plaintiff. The plaintiff does not have to repay those fees. If it's assessed to the defendant, though, then the defendant has to reimburse for the court costs, usually about $128. So next we use what's called a payment plan. This is not for every agreement. This is only whenever you have a lot of payments or they go on for a long period of time, they're confusing, those types of things. Okay. And so this piece of paper is relatively straightforward. Just make sure that you're filling in every blank. Of course, well, sorry. Make sure that you're filling in every blank unless there are less payments required than there are slots. So you'll see that there are 12 total slots for payments, and if you only have 3, you only need to fill 3 of those out. But pretty much everything else you'll just fill out, right? So how many payments are being made, what's the total amount of money, make sure you put this final payment on the bottom. Form of payment can be left blank, but you want to at least ask the parties what that's going to be, delivery address for that payment. So just make sure you're asking those questions if you use the payment schedule. Yeah. And then this is a relatively new document that's used in the city, but not the county. It's called our consent motion and order to raise security level at time of dismissal. Okay. So if you're familiar with CaseNet, that's how Missouri shows its court records. So if you were to search for someone's name, you could see any pending or previously adjudicated cases of that party, so long as the security level has not been raised. If you're familiar with sealing records or something like that, it's the same thing. So in Missouri, we call it raising the security level. And so this document, if the agreement is met, raises the security level to level 3, which means that only the courts can see it. So it means that the public can't see it on CaseNet. So this is really helpful, and we ask every mediation in the city, if they reach an agreement, if they're willing to sign this. So the advantage to the defendant or the tenant is very obvious in that their name and this case of eviction against them is removed from CaseNet if the case is dismissed. So if there's a judgment against them, if they fail to meet the terms of the continuance, this does not apply. This is only if they meet the terms of the continuance. For the landlord, it means that the case is no longer posted on CaseNet, so it's one less case for them kind of publicly. So especially if they're trying to kind of keep a record of being a friendly landlord or being a negotiable landlord. In family cases, we usually find they are very willing to sign this so that their son, cousin, aunt, doesn't have an eviction following them for the rest of their lives. So a lot of family cases really appreciate using this document. In the county, they basically said that we can use it on a case-by-case basis, maybe. So let's say you do have a family situation, you might consider using this. You might consider asking whether they want to raise the security level. We just can't make it a regular practice yet. Questions about these last 2 pieces of paper before we move on? So some of the dynamics that come into play, particularly in regards to motivation. For a landlord, timing is really important. So if it's in the city, they're showing up for the day of trial. But if it's the county, then there's that right to continuance. So then it's being extended. So you have the day of trial, and then you have a judgment, which might be entered that day, usually not until the following day. And then you have 10 days, and then you have the execution, and then you have the exit of tenant. So we're looking at kind of this relatively long, drawn-out timeline. So mediation just gives a little bit more expediency for landlords kind of for the process, partly because going to a mediator is it's required to talk to a mediator, not necessarily reach an agreement. And we are faster at getting resolutions than waiting for the judge, because there's usually one judge and there are usually multiple mediators. So going through the mediation process is a little bit faster. So if you're finding that a landlord is like, I really just want to get out of here, that's usually a great motivation. Great, then let's reach an agreement. You can go. As soon as you figure out as soon as you all figure out this agreement, we can get it signed and we can have you out in minutes. Okay. In terms of finances, the exit of the tenant is less dangerous to their property, or less costly. So tenants who make an agreement are less likely to damage the property. They're less likely to have these kind of violent exits. The landlord is more likely to recover past rent owed. So we've found that so the chances of a landlord getting the full amount of money that they are owed from a judgment is relatively low, because we're working with folks who are already low income. So that means that if you get a judgment against a person, if a landlord gets a judgment, in order to get that money, they have to file a garnishment or a lien or something like that. These are very difficult to file, especially against very low income folk, because government subsidies cannot be garnished, generally speaking. Okay, so if someone's on SSI, if they're on disability, their food stamps, that can't be garnished. Okay, so they're more likely to get at least some of the money owed. And then lastly, they can reinstate a paying tenant. So sometimes there's an emergency, someone falls a bit behind, and the landlord doesn't necessarily want the tenant gone, they just want their money back. So this can be a way to have that tenant stay and get caught up on rent. And then lastly, to save face. So keep in mind that many landlords are either small homeowners who have names in the community, or they are regulars. And if someone's a regular and every time they come in front of the judge hears about the awful condition of the premises, that might have an impact on what the judge does in future cases. It's not supposed to, but it might. Okay. Why do tenants want to mediate? So we avoid judgments on their record, which is very important. They often get more time to move out or more time to pay back rent. A lot of times you'll hear from tenants, there's just not enough time, or I just can't do it within that time period, right? So a mediation is longer, or a mediation allows for longer agreements than court. Remember, if they go to court, the tenant's going to have 10 days. That's pretty much it, right? So we get a lot more flexibility. Most importantly, though, we find that the opportunity to be heard can really have a massive impact, especially whenever there's a lot of times we will hear from tenants, my landlord doesn't care, my landlord's being rude. Usually we'll hear that in maybe more explicit language. The place is a pigsty, things like that. And so that opportunity to be heard by the landlord and by a neutral party can be really helpful to a lot of tenants. Now, on the other side, why do folks not want to mediate? So for a landlord, they're going to win at trial 99% of the time, right? So if they just want that judgment, going to the judge is going to make that very easy for them. Many times landlords take it personally. They're personally invested, especially small-time landlords where they own maybe 2 or 3 units, might be they're renting a family home that was left to them. They'll take it personally too, right? And so whenever someone's very personally invested, it can be very challenging to mediate based on the issues, right? Many landlords think it's too much effort. They don't trust the process. Sometimes they think that we're just there to protect the tenants. And this can be especially challenging depending on where you say you're from. So saying that you're from the St. Louis Mediation Project is very different than saying you're from, a tenants' rights organization, for example. And then why do tenants not want to mediate? So sometimes there's a distrust or misunderstanding of the process. So they don't understand what mediation is for, or what really our role is. A huge one is a desire to be heard by the judge. A lot of times you'll hear tenants say, well, I just want the judge to hear what's going on. And quite frankly, the judge doesn't care. And the judge is going to, 98% of the time, they're going to enter judgment in favor of the landlord. So you'll hear this, and it's important to be ready for it, and think about strategies about how to kind of mitigate that. One way that I've found that works really well is, what do you think the judge will do? And oftentimes they'll say, well, I just need the judge to hear this. Great. And if that happens, what will the judge do? Right. And usually if we go down that path, folks will kind of come to an understanding that the judge really doesn't care, other than whether or not rent is owed. So then arguments about conditions or habitability, especially if the place is really bad, or maybe unlivable or barely livable, that can really be a challenge in a mediation, especially if a landlord isn't willing to accept less money or there's challenges with move out. Many tenants will also take it personally. They don't want to cooperate with the landlord, especially if the landlord's been a jerk. And sometimes there's harassment happening. So if there is harassment, whether it's sexual or physical, please let us know. Mediation is not effective if one party is on an uneven playing field than the other in terms of their ability to participate. Right? We recognize that the landlords often have a lot more power, but if their ability to participate is so different, that can be really challenging. So sometimes we might use a co-mediation model, or that might be a case where the supervisor might say, we can't work with this situation. It could have a really big impact. So if there's a restraining order, we've had that come up. So just ask a supervisor. We'll brainstorm options. Sometimes we'll talk to the judge to see what the judge wants. We'll consult with each other sometimes. So just come ask a supervisor and we'll help out. So any questions about the motivations and these kind of beginning dynamics? So one question, what if the tenant is cognitively impaired? So we are going to address that in a second, but usually the requirement for the judge is a finding of what's called competency. And the finding of competency is very low in Missouri, especially in this court. So the judge will more or less ask, do you live in the unit? Do you understand that you have to pay for living in the unit? If the answer to both of those questions are yes, usually they're competent. And so if they're competent for trial, then they're competent enough for mediation. If I find that I'm having a hard time connecting with a party, particularly a tenant, because I feel like they don't understand what's going on, I slow things down and I ask frequently, do you understand what this means? Or do you have any questions? We often find that folks might be impaired because of substances, right? And so the same kind of things apply. So mediation strategies, many of you have already been through lots of mediation training, probably even more than I have been. But here are the main things that we find really helpful within this particular context. So number one, be yourself. So everyone has a different strategy that they find effective. Some of our mediators focus on the numbers and use that as a tactic to really kind of reach an agreement. Other folks are focused on the people, right? What are the challenges that people are facing? What is the process? Other folks are really good about moving towards an agreement very quickly. Okay, I'm hearing these challenges. What are we going to agree to? So really just be yourself and find a style that suits you. So we don't usually use co-mediation as our primary mediation model, but it is, but we are open to it. Usually we just don't have the capacity for co-mediators, but if you think a co-mediator would be helpful, we're not opposed. Just kind of bear in mind that capacity piece. Just let us know. The day might be a little bit longer, but if that's your style, if that's more comfortable, great. So two, Active listening, so this means that you are listening not to respond, but to actually listen. So if someone says something, try to reflect back what you heard in a short summary. If someone's talking about a feeling, you can reflect that feeling, right? But don't listen to someone just for the purpose of telling them that they are wrong, or things like that. There are times when you'll need to cut someone off, so it's a tricky balance between giving someone space and letting them kind of take over or take too much space. Third, be empathetic. So these are folks who are struggling on both sides. So many landlords are scraping by in terms of their mortgages, and so rent is barely enough to cover their mortgage and utilities and upkeep costs. So be empathetic to that. Also be empathetic to the tenants who many times are struggling with the reality, especially of poverty, and the challenges about not knowing where one's going to live is really scary. And lastly, steer parties toward relevant issues. You're going to hear a whole bunch of stories about a whole bunch of unrelated things. Well, the reason that I met my landlord was through my sister's best friend, and they were dating at the time, and now they're not dating, and now they're not talking, and that's made things really complicated, right? That was something that I heard at my very last mediation before the break. So keep in mind that the parties are going to want to talk about a whole bunch of things. Sometimes they're not relevant, so steering them towards the relevant issues is going to be really helpful. Like, what is the relationship between the parties? Where were some of the failures that happened that led to where we are? What are the things that we can agree to make sure that those failures don't happen moving forward? So we recommend also clarifying options for parties. So again, you have a lot more flexibility as a mediator than a judge does. So you can draft an agreement to do most things. If you're curious whether or not something is enforceable, just come ask a supervisor, and we're more than happy to help. I often also find that just kind of giving folks what are the available options can be really helpful, and just say, especially based on the issues you're hearing. So like, oh, well, we really want this relationship to continue. Our main challenge is just a lack of payment. Usually we'll say, oh, great. We can create a payment plan in addition to regular rent. Is that something that you're interested in? Or are you interested in maybe a different solution? What would that solution look like? Okay. Separate interests from positions and people from their problems. So just because a landlord says, I need $1,500 today, and that's all I'm going to agree to, right? That's not really a good faith attempt at mediation. So try and figure out, why do they need that $1,500? What is it? What is it specifically helpful for, right? What are they trying to get? Oftentimes folks will come into a mediation, especially if they've been through one before, with this idea of, well, if I just walk in aggressively, I'm going to win the mediation. And so undoing that idea of winning can be really time consuming, but also can be really helpful to actually reach an effective agreement. Encourage the parties to actively participate. So especially if you notice that one party is being quiet or shy, encouraging them to participate, really elucidating, what are your thoughts about this? Do you have any reactions? Those types of questions can be very helpful. And if you find that the parties are resistant or hostile or aggressive, caucus. So that's when you separate the parties and you go back and forth, giving them approximately equal time, and you just kind of convey what the other party said. Sometimes you can caucus just by yourself, where you go back and forth between the parties. Sometimes you'll caucus with a co-mediator, where each mediator will talk to a party, and then the mediators will share, and maybe they'll go back to the same party, or they'll switch. Okay. So oftentimes whenever you're working with folks and there's a lot of hostility, I strongly recommend having them caucus so that they stop screaming, just for the kind of the sanity of the court, as well as your own kind of sanity in that space. So just remember, take care of yourself, If you find that you're getting stressed, chances are that's not going to be a great place to mediate from. And so again, caucusing is one strategy to help mitigate that. Always feel free to use a supervisor. So I received another question. How do you deal with a bully? And that is an incredible question. And it really depends on the type of bully. If we find that one person is kind of physically aggressive, or has been physically aggressive in the past, sometimes we might have a sheriff come and stand over the parties, and the presence of the sheriff can calm people down, or at least make them a little bit more hesitant to be aggressive. Oftentimes we'll caucus. So I very often will separate people and just say, I would like to try a new strategy. I'm going to have you all sit on opposite sides of the room, and then I'll just walk back and forth and figure out if we can reach an agreement that way. Clearly, what's happening right now isn't working. Let's try this. If you find that you are being bullied, sometimes, no. If you're being bullied, talk to a supervisor. We will support you. Sometimes that means that someone else will handle the mediation. Sometimes that means that we'll tell the judge that a party was being aggressive to a mediator. So we've done that before, and the judge called up the parties, told the person, you are being aggressive to a mediator. I'm not going to allow that. If you want me to hear this case, you need to attempt mediation. But I'm not going to allow you to be aggressive to the mediators. And after that, the parties reach an agreement. So sometimes the judges can be supportive in that capacity. So some of the main mediation issues that we see. So again, remember I said we only mediate where both parties are present. Surprisingly more complicated than you would think, because oftentimes people will send all sorts of other folks to court on their behalf. Okay. So if you send your sister to court on your behalf, you are not present. Your sister cannot sign an agreement on your behalf absent some special paperwork. Okay. So you'll often hear, oh, well, my son or my mom, they're the actual party. I'm just here to help them because they're whatever. Usually that person can go to the judge and the judge will issue a continuance instead and will say to the person, that party needs to be here. You cannot represent their interests because you're not an attorney. The exception to this is if one party is married to the other one. Usually that's enough, especially if we're talking about a landlord where the name of the case is, maybe the husband has the case and the wife shows up, or maybe, both tenants. So maybe, if two partners are tenants together and only one of them shows up, usually that's enough to kind of represent the full case if they are married. If a plaintiff is an LLC or a corporate entity, let a supervisor know. An LLC is supposed to be represented by an attorney, not by an individual. So even if it's a sole owned LLC, usually it's supposed to be represented by an attorney. The supervisor will chat with you a little bit about what's going on and figure out whether or not mediation is appropriate or if we just send it to the judge. Okay, so keep in mind, if you're suspicious about whether or not a person is who they say they are, just let a supervisor know and we can brainstorm a little bit about options. So another issue, a non-party has influence or power. So keep in mind that you as a mediator are only responsible for the parties in the case. So sometimes someone will bring a sister or a best friend who will be a very vocal advocate for whoever they brought with them. Sometimes that's helpful. Many times it's not helpful. Usually the non-party is more aggressive than the party, and that can make mediation very challenging. So keep in mind who has a right to speak within that space. And I have asked someone before, I really appreciate you advocating for your brother, but I need to try and see if they can reach an agreement. And I'm wondering if you would be okay kind of sitting to the side while I talk to the two parties. I'm having a hard time communicating with them. And I've had to do that before. Third, issues with mental capacity. So we talked a little bit about this. The bar for mental capacity is very, very low. Keep in mind that supervisors are always available. If there's a situation you've not seen before, come ask us. We've seen a lot more situations. We have a broader breadth because of our role. Both Sam and I have done plenty of mediations. We've also heard about lots of mediations. We've troubleshooted a lot of challenges, and we're both attorneys. And so we have some of that legal experience that can be really helpful. So if you are having a challenge, just come ask us. And then consider using multiple mediators, again, especially if there's aggression, if you're feeling unsafe, those types of things, that can be a really helpful strategy. So this is what Sam calls the coffin of our mediation plan. And really it just shows that we start relatively narrow, we go broad, and then we kind of re-narrow at the bottom. So we're still debating whether it's a coffin or a diamond, but here's where we are. So you're going to start with your introduction, right? That's very specific. It's very narrow. It's that paperwork. The parties must sign the agreement to mediate before you mediate. If they try telling you their story before that time, stop them, say, I'm sorry. I am very excited to listen to you. I'm not allowed to listen to your story until you've signed this agreement. Then you'll move into stories and positions. Usually we start with the landlord and we'll be explicit. So now we're going to start the mediation. I'm going to hear from both of you. You're both going to have an equal chance to say what's going on. Just for ease of convenience, I'm going to start with you, landlord. Listen to both sides and kind of figure out what's going on. Then you recognize emotions and identify relevant issues, right? So that's really where we're at the broadest. So folks are really going to be having a lot of emotions at this point. They're going to be noting a whole bunch of relevant challenges as well as irrelevant challenges. So you're going to start narrowing down at that point, really consolidating what are those relevant issues? What are the things that actively impact the case at hand? Okay. From there, you can identify possible solutions. Usually this is done with, so what solutions or how do you think we can move forward? Right? What solutions are going to work? How can we move forward? How do we fix this issue that's happening? You'll then narrow down what are the areas of agreement and the areas of disagreement. If something's in agreement, write it down, and then you have that as something to refer back to. And then if something's in disagreement, write it in a different section so that it's very clear. I strongly recommend bringing scrap paper to every mediation. You don't have to save your notes, you can throw them away. But I find it very helpful for me. And it's helpful, especially for new mediators, to just kind of keep track of everything that's going on. So then you'll reach what's called the agreement in principle. So that's where it sounds like we have an agreement, and then you'll write out the terms of the agreement in shorthand. And you'll say, is this what you're agreeing to? Are you okay with this? Are you okay with this? And then inevitably you're going to have one person say, oh, well, I thought it was like this. Okay, fine. And then you'll just keep writing until you have the agreement in principle. And you do that on scrap paper so that you don't have to go through a bunch of copies of the paperwork that we give you. And then once they've agreed to that, then you can draft the signed agreement. Okay, so that's the very last step. And then you'll draft all the paperwork, you'll have the parties sign it, and then you'll take it all to the mediation supervisor. We'll chat about it a little bit. We might have some recommendations, we might have some fixes. For your first few mediations, usually once you have that agreement in principle, bring that to us and we can help you draft the agreement itself, okay? So if you're struggling, you're new, feel free to bring that to us and we can help with drafting the agreement before they sign it. And then they'll sign it, you'll give it to us, and then we'll bring it to the judge. So I have another question, and this one is, how much time to reach an agreement? Good question. So our mediations have been as short as 5 minutes and as long as an hour and a half. So we don't set hard time limits other than the judge ends court at noon in the city on Fridays, usually, and at 4 to 5 p.m. on Tuesdays in the county. So once court ends, every agreement needs to be in before court ends. So usually in the last 30 minutes, the judge will get antsy. They'll say, what's going on? A mediation supervisor will come out and we'll say, the judge is getting ready to go. Can you all start wrapping it up? So you don't have to worry about it too much. Usually the parties will kind of go at their own pace and you can go at your own pace. But we'll let you know once things need to reach an ending point.
And Wolf, if I could add just quickly too, it also can kind of be used though strategically as far as, sometimes you kind of get bogged down in that middle area of my coffin where it's still kind of too open and you're having trouble keeping the parties turning in towards a possible solution. And sometimes we'll catch the eye of the person who's mediating and kind of come over and kind of, as supervisors kind of performatively try to push it forward, right? Like maybe like, oh, it looks like the judge is moving the, other cases forward, or try to put some kind of almost, again, performative pressure on that group to keep moving.
Yeah. And sometimes even just having the supervisor come over and say, how are things going? Can I help at all? Usually that's more for the parties to see than like a mark against the mediator themselves.
Yeah, absolutely. Mm-hmm.
So you might see, especially if you've been out there for an hour, you might see, Samurai come up to you and say, hey, everything okay? Anything I can do to help? Usually that's just so the parties are like, oh, we've been here a while, we're taking up a lot of time, as opposed to you as a mediator are failing in some way. That we never approach it from that direction. We're always just trying to provide support as much as possible. So just some legal ethics, especially for lawyers in the room. For non-lawyers, these also kind of apply to you. So these rule of ethics come from the Lawyers Code. So 4-1.12 basically says that if you were a mediator for a party, if you mediate for another party or were to represent another party, you must have informed consent confirmed in writing. Okay. This is specifically for representation. So if you mediate between the two parties and you then were to represent one, you have to have this informed consent in writing. So really, we don't want that to happen. And for lawyers serving as a third party neutral, you have to let them know that you're not representing them. For non-lawyers, you should also do that, right? You want to be very explicit that they are not your client, right? You're not creating an attorney-client relationship. There's not privilege, there's not confidentiality, okay? And here are kind of the main things. I'm not going to go through each of them, but there's a whole lot of reasons that we want you to be mediators and not legal representatives. Most of which is to save you a lot of stress and hassle, right? And complications. So just be very explicit in the beginning of your mediation. If you're an attorney, say, I am an attorney, but I am not your attorney. I am not representing either of you. I cannot give you legal advice. I can only give you some general legal information. So you might hear me say, here's what I've seen the judge do before. That's not advice, it's just some general information about what I've observed. So we're on our last slide, so we'll have a little bit of extra free time for if there are final questions that folks have. But I just want to expressly say thank you. Our mediators are the backbone of our project. And we really couldn't do it without the support of all of our mediators. I know that the tenants are really grateful, even if they won't express it. The landlords are grateful, even if they won't express it. The community is certainly grateful, and you will often hear that the court is grateful.